Without further ado, we are here with our presenters today, Rex Daines. He is a local bankruptcy attorney here in Bend, and our very own Arianna Lease, Escrow Officer Extraordinaire. Together with their combined experience, they've seen a lot throughout their careers. So I have no doubt this presentation will be full of a lot of really great information. So Rex, I'll let you take it from here.
All right, thank you. So I'll just tell you a few things about myself, and then I'll tell you one of the 3 lawyer jokes I know, and then that should make everybody feel comfortable, or at least make me feel comfortable. And we'll talk about bankruptcy, and specifically bankruptcy related to real estate issues. So I graduated from Willamette Law School in Salem in 1995, and I was never going to be a bankruptcy attorney, but the only job I was able to get out of law school is as a bankruptcy attorney. I was lucky there were only 7 in my class of 150, approximately 150, who had a job as of graduation. So I felt very lucky to even have a job. We were in a recession at the time, and I wasn't paying attention to recessions that much at the time because I was young, and those things didn't matter a whole lot, and they matter a lot more now. But so I became a bankruptcy attorney. The head attorney in our firm has since retired, but shortly before I started, he opened satellite offices in Medford and Grants Pass. And so I would drive every week from Salem to Medford and Grants Pass. After a while, the senior attorney got bored, so he thought he would get a plane and he would fly to Medford and Grants Pass. And so I took over his Portland cases. And then after a few more years, I convinced my partners that I could work effectively in Bend, Oregon, and they should let me move to Bend, which they did. So I got to move to Bend. I'm still part of the same firm. It's based in Salem. We're the largest consumer bankruptcy firm in the Northwest. Last month, for example, we filed 20% of all of the bankruptcies filed in Oregon. Usually we're around 16 or 17%. But it's a big firm, about 40 employees altogether, and our primary focus is bankruptcy. So I've had a lot of experience, which means I'm old. It's a nice way to say I'm old, but I've had a lot of experience, taken a few bumps and bruises along the way but it helped me learn. So I'm thankful for that. So here's my one of my 3 lawyer jokes. So there was a guy, and he really wanted to prove that the adage "you can't take it with you" is wrong. So he came up with a plan. He thought, well, I'll trust 3 people, and they will help me take it with me when I die. So he goes to his accountant. He says, "Account, here's $10,000. I don't owe you any money. I just want you to hold this. And when I die, I want you to come to my funeral and put it in my casket so I can take it with me when I die." And the accountant says, "Sure, no problem. You're my friend. I'm happy to do it." And then he goes to his insurance agent. He's known him for years and years and years, and same thing. "Hey, I trust you. Here's $10,000. Please put it in my casket. At my funeral, I want to prove I can take it with me when I go." And then the last person, he thought it was his attorney, and he thought, well, okay, if both of these guys fail, maybe my attorney will do it. So he goes to his attorney, gives him the $10,000, same instructions. And then, of course, the guy dies, and the attorney, the insurance agent, and the accountant are at the funeral all talking, and one of them says, "Hey, did you guys really put your $10,000 in?" And the accountant says, "Well, guys, I really wanted to, but this tax preparation software is very expensive. I needed a new computer, new software. So I spent $7,000 of it, and I put the other $3,000 in." And so the attorney and the insurance guy, they're like, "Oh man, are these guys going to ask me if I put mine in?" But they did, of course. The accountant definitely wanted to know if the other guys stepped up. So the insurance agent had kind of the same problem. Insurance sales were down. He needed some money to live on. He said, "But I did put in $5,000, which he was pretty proud. It's more than the $3,000. And then, of course, they both look to the attorney and say, "Hey, attorney, did you put in your $10,000? And the attorney said, "Of course I did. I put in a check for the whole $10,000. That's my lawyer joke. Lawyers are kind of scummy sometimes, but we don't even use checks anymore. If you're under 30, I don't even know if you get that joke, because Because my kids, they don't know what a check is, but I know what a check is.
Yeah.
All right, so that was my little joke. All right, so we're going to talk just generally about the bankruptcy process to give a framework. Then we're going to talk about the different types of bankruptcies and when and how sales happen in relation to those bankruptcies or after those bankruptcies. And then we'll talk specifically about judgment liens, second mortgages that haven't been paid on forever, tax liens, and then if we have time, we'll talk about some divorce issues which can come up and create problems for title companies when the ex-spouses can't agree. So a bankruptcy is a process under federal law where people are enabled to eliminate their debt and they never have to pay it again. When a bankruptcy is filed, there's a bankruptcy petition that's about 50 pages. And the petition lists all of a person's assets, all of their debts, all of their income, and then some historical information about transfers and income and stuff the last few years prior to the bankruptcy filing. The court uses this information to determine whether or not there's enough income to pay creditors back some or all of their debt, or whether there's some assets available to pay back some or all of the debt. The whole process for a bankruptcy usually runs about 3 months. And that's true for a Chapter 7 bankruptcy, which is called a liquidation, or a Chapter 13. Takes about 3 months to get a plan approved by the court. And then a person makes payments for a long period of time during a Chapter 13. Those are usually the cases where a lot of you have become involved, where people try to sell a home or even buy a home during a Chapter 13. In either type of bankruptcy, the court appoints a trustee, and the trustee has a lot of say regarding what happens. From a legal standpoint, when a person files a bankruptcy, all of their assets are instantaneously owned by the bankruptcy trustee. And that's kind of a strange thing to think about because it doesn't make practical sense, but from a legal standpoint, it makes sense. It ensures that someone can't sell their property without going through a process through the court. A court doesn't want to have someone in a bankruptcy and then have assets disappear that should be used to pay creditors. In a Chapter 7 bankruptcy, again, it's usually completely over and done within about 3 months. During that 3 months, the trustee appointed by the court conducts a hearing. And when real estate is involved, the trustee asks the people filing bankruptcy how much they believe the property is worth and how much they owe on the mortgage on the property. The reason the trustee does this is he wants to know if there's any equity above the allowed homestead exemption. The homestead exemption in Oregon is $40,000 for an individual and $50,000 for a married couple. When people file bankruptcy, they can elect to use federal exemptions, which are about $30,000 for an individual and $55,000 for a married couple. When someone files bankruptcy and the equity position in their home is above the homestead allowance, then the court sells the property. The process, some of you maybe have even been hired by a bankruptcy trustee in the past, but the process is just like when a regular person files a bankruptcy. It's not an auction process. It's a normal MLS listing, home sale process, with the exception that as soon as there's an offer on the home, that offer has to be conveyed to the bankruptcy judge so that other parties related to the bankruptcy can object if they don't think it's a fair deal. The homestead exemption in Oregon is very old. It hasn't been updated for about 30 years. In all of our neighboring states, the homestead exemption is extremely more favorable for debtors than it is in Oregon. In Washington, for example, the homestead exemption is the average sale price in a person's county. So someone, for example, lives in King County in Seattle, they can have a homestead of about $750,000, which means they need more than $750,000 equity before the bankruptcy court can take the home. Nevada and California are in the $500,000 range. Even Idaho, where home values are a lot lower, it's 150,000 for the homestead exemption. So Oregon's kind of out of touch as far as the homestead exemption goes. But it is what it is, and that's what we have to deal with. So a very basic set of numbers to give you an idea how it works. If a person has a home worth $100,000, which is kind of laughable in 2023, but when this homestead amount was developed, it was a pretty normal amount for a starter home. $100,000. If a person, single person, owes $60,000, that would give them $40,000 equity. Their home would be protected in bankruptcy, which means the court wouldn't sell it. The person keeps the home, and the bankruptcy is closed out. When a person has some non-exempt equity in the home, so let's say their total equity position is $60,000 in the home, and they're allowed a $40,000 homestead exemption, then they're $20,000 over the allowance. Typically, people won't do a regular Chapter 7 bankruptcy because they don't want to lose their home, and so they file a Chapter 13, which is a reorganization, and they pay that $20,000 over time through the bankruptcy court. So all of the creditors share in the $20,000. Same amount of money they would have got if the court had sold their home in a Chapter 7, but people are allowed to keep their home and pay that dollar amount over time. So we'll back up to Chapter 7 just a little bit. If the court elects to sell the home, then it's listed like normal, an offer is made like normal. The process through the court is about 30 days for the bankruptcy trustee to file a notice explaining how much the home is going to sell for, the payoff on the mortgage, the title and escrow fees, any other liens that might be on the property, so the trustee can show the court that there's more than the homestead exemption. Anybody related to the bankruptcy in any way can object. So let's say any old credit card, Discover card, looks at the situation, says, well, we think this home's worth $300,000 and they're trying to sell it for $250,000, and so $50,000 is disappearing. Discover card can object and say, hey, judge, here's some proof that the home is worth a lot more than they're trying to sell it for. The judge has a hearing, and ultimately the judge decides whether it's a fair deal. As you all know, if that amount of time happens, the sale is probably going to fail anyway. Since most parties know that, there's very rarely an objection in bankruptcy to a home sale. As long as the price is somewhat reasonable, everybody knows an objection is going to have the effect of killing the sale, and then everyone hoping that another sale comes up. Chapter 13 is where you're going to more frequently see home sale issues in bankruptcy. So the way it works is there's a Chapter 13 plan filed with the court the first day of bankruptcy is filed, and that Chapter 13 plan explains how people are going to pay the dollar amount they have to pay. We'll just stick with the $20,000 example. So let's say somebody has to pay $20,000. The bankruptcy court gives them 5 years, but they're on very, very limited income, maybe retired or just very static income, and not a lot of ability to pay a high Chapter 13 monthly payment. What we typically do is we set up a monthly Chapter 13 plan of $100 or $200 a month. And then we have a provision in the plan that says at some point, usually about 3 years down the road, these people are going to sell their home to pay the difference. So over time, they'll pay $2,000 or $3,000 towards the 20, and then they have to sell the home in order to pay the difference. If sale of the home is part of that initial plan, then in order to close the account, a title company does not need an approval order by the judge. They only need an approval order by the bankruptcy trustee, because the dollar amount they have to pay and the fact that they're going to sell the home is already part of the original plan. A lot of times, though, people set up a Chapter 13 thinking they can afford to pay the $20,000 amount over time, but then things happen and it doesn't work out. So they default on their Chapter 13, or just simply don't have the money to keep paying and pay this dollar amount that's required by the court. In those cases, people will list their home for sale, but the process is different. Since the judge hasn't already okayed the process of a sale, a motion has to be filed with the court to say, hey, judge, we're selling. This is different than the original plan. We need your approval. And so the title company in those cases needs that order signed by the judge saying, this wasn't part of the original plan, but we're agreeing to it now. This comes up very, very frequently. It comes up so frequently, the judges got tired of them last year. And so the Oregon, there's 4 bankruptcy judges in Oregon, they got together and they made a brand new form. And this new form was implemented December 1st, but the new form lays out everything the court wants to know in order to approve a sale in a Chapter 13. So probably none of you have seen that yet. I think in our firm, we just have the very first one that we just filed. So it's going to be a PDF with fillable blanks, and the order also approving the sale that the judge will sign will be a PDF with fillable blanks. So that's something you will be seeing in the future. I think it's a very good idea because it makes it a lot more uniform. It'll make it easier for realtors and title companies when they see these to say, okay, now we're comfortable with this process. And I think it'll make it easier for all of us, for people on my side and your side, and to get these approvals by the court on the sales of homes. Still with Chapter 13, a lot of times this creates a delay and the sales fail, or somebody's interest rate lock expires or something like that. Can create a lot of problems. What the 2 documents that always have to be attached to the Chapter 13 motion for order allowing sale of the home is a title report and an estimated closing statement. The estimated closing statement is hard because there's guesses early on, but it's better to submit one with good guesses to the court so the time frame can start running, and then supplement it with an amended closing statement when changes come up. The reason the court needs to see a title report is frequently there are liens that people didn't know about, like they got sued 10 years ago and there's a judgment lien on the property, and when the people filed bankruptcy, they didn't even know about it. It's a lot easier now to look those kind of things up online. Historically, that was a huge issue, and people didn't know about it. People didn't want to pay for a title report before filing a bankruptcy because it added to the costs. So still see that quite frequently, though, where people didn't know about a particular lien on the property. All right, so judgment liens. A lot of you have had clients sell a home regardless of the bankruptcy status, and they're selling a home and they have judgment liens they have to pay off. Probably you've had cases where you get to closing and there's not enough money because Discover Card filed a judgment 15 years ago and it had credit card interest rate, and somebody who owed $5,000 now owes $25,000, and everybody's surprised and nobody can close a deal and everybody's mad. So that happens a lot. The rule about judgment liens is judgment liens can be eliminated if they impair a homestead exemption. So back to the first example, home worth $100,000, $60,000 mortgage on the home. If there is a judgment lien on the home for any dollar amount, that judgment lien can be completely eliminated either in bankruptcy court if a bankruptcy had ever been filed, or in state court wherever the original judgment was initially filed. The problem with this, with most things in real estate, is timing. A lot of times learning about those judgments comes up so late in the process that people cannot file the motion and get an order avoiding that judgment in time to sell. In fact, we had and this was a big ugly case. The guy was accused of elder abuse and a whole bunch of other stuff. So it was a huge judgment, $300,000. And so we filed a motion to partially void this judgment because it partially encroached on the homestead exemption. The attorney on the other side filed an objection, and the court set a hearing 6 months later. So you can imagine that sale, of course, died. Luckily, by the time we got another offer, the creditor who has the judgment realized if they keep objecting, the real estate market already started tapering off last year. They realized if they kept objecting, that every time they objected, they're going to get a lower offer on this home and they're going to end up with even less money. So it ended up working out, but it was very frustrating for a lot of people because a creditor can really gum up the works by filing an objection because the courts are so backed up, they can't set a hearing that quickly to get these things resolved. What the judge has to determine at the hearing is what the true value of the home is, and that the person isn't selling it for less than full value. And so that typically requires getting appraisals, which takes time and money, and just scheduling a long enough hearing on the court docket that the judge can make that determination. A lot of people think a bankruptcy has to be filed in order to claim the homestead, and that's not true. Anybody can claim the homestead and file a motion to void a judgment lien when a sale is about to happen on a home. So if any of you ever have a client that you're trying to help them sell the home, when you see that first title report, if there's a judgment on there, you don't want to give legal advice, but you want to tell them to get legal advice, and just say, call any attorney in the state. It's not a difficult process, but it's something where you got to get that clock ticking if you want to get an order voiding a judgment lien before you close the sale. The attorneys most comfortable in, say, doing it are attorneys like me who do bankruptcy because we see it more frequently. But really any civil attorney who does anything in state court very frequently is going to be able to do that type of work. Fees are usually under $1,000 unless there's a hearing where the judge has to determine the value. But just the initial paperwork and everything is a $500 to $600 expense usually for people to get rid of judgment liens. Title companies, before the recession that started in 2008, title companies would do a holdback, and I don't think any title company does that anymore. I think some of them lost some money back in the last recession, but we used to be able to write a letter saying, hey, hold back $50,000, we're filing a motion to void this judgment lien, and once it's voided, then you can give the rest of the money to the seller. I don't think that happens anymore, but maybe someone else, Hannah or someone, can tell me if title companies still do that once in a while. The last few times I've asked, they've just said no, because there's a risk to the title company that they don't want to take, which is totally understandable. All right, old second mortgages. In the last recession, a lot of people quit paying on their second mortgage, and the second mortgage never foreclosed because the second mortgage had no incentive to foreclose because they would have had to pay off the first mortgage, and there wasn't enough equity in all these properties when the market crashed. And so second mortgages just completely stopped collecting, but that doesn't extinguish the second mortgage. It's still sitting there. I get about one call a month from somebody in the state of Oregon who said, hey, I stopped paying my second mortgage in 2010. I'm trying to refinance, or I'm trying to sell. And now these people say I owe, whatever, 3 times the amount of the original second mortgage. And usually they're right. There's 10, 11, 12 years of interest. There's a late payment fee every single month. There's collection costs and lawyers' fees, and a very small second mortgage becomes a very big second mortgage. Legally, except one exception I'll tell you in a minute about timing, but legally there's usually nothing we can do about those second mortgages other than make a deal. And the second mortgage companies are usually willing to make a deal, but they're going to hop online and look at Redfin or Zillow and say, I wonder if there's a ton of equity in this property. They kind of use that as their benchmark. And if there is a ton of equity, sometimes they just say, no, you can pay us in full, or just keep doing what you're doing. The timing consideration for second mortgages is a statute of limitations starts on the date the last payment was due. So if somebody had a 15-year second mortgage and they got it in 2005, then in 2020 is when the statute of limitations would start for somebody to file a motion to eliminate that second mortgage, even though it was never paid. Those are very, very rare. Most second mortgages are 30-year notes. And so even somebody who would have defaulted in 2005, they're still, I shouldn't have said that. That makes tough math for me. They're still 12 or 13 years away from being able to even start the statute of limitations, which then has to run, and then people can file the documents to have that second mortgage voided. The documents that get filed at that point aren't a motion to void a lien. It's called a complaint to quiet title. Those aren't utilized very often, but complaints to quiet titles do happen. They happen in two circumstances. This one where an old mortgage is timed out. And the second one is where a second mortgage company filed a lawsuit against the individual. So in Oregon, we're called a trust deed state. That means when somebody gets what they think is a mortgage on their home, they're really signing a note and signing a trust deed. So the trust deed and the note are mirror images of each other. But a mortgage company doesn't have to be a second, but it's usually a second mortgage. They can elect to sue on the note. And this we see quite often. The reason a second mortgage company elects to sue on a note is because then they can get a judgment and they can garnish wages. And when they have people that they think they have consistent, solid, good income, but they don't have any equity left in their property, this is a way for the second mortgage company to get some money. So they sue on the note and they say, hey, you owe $80,000 on this note. We want a judgment. They get a judgment, and then they can garnish wages. When a company sues on a note, that in Oregon is called an election of remedies. So they elected to sue on the note instead of electing to foreclose on the trust deed. There's a case law out of bankruptcy court. I don't remember the name right now. It's easy to find, but Judge Brown, who's now retired bankruptcy judge, wrote an opinion that said if second mortgage elected its remedy and sued on the note, it can no longer take any action against the trust deed. It cannot foreclose the trust deed, which allows an attorney to file a quiet title complaint in state court and have the judge eliminate that trust deed. So these are easy to spot because on a title report, you'll see a trust deed, and you'll also see the judgment entered on that note, again, usually by a second mortgage. Those are important to spot because if a title company or a homeowner asks the second mortgage company for a payoff, they're going to give a full payoff. And if nobody's the wiser, then they pay off the second mortgage in full when they didn't have to. Since now there's a judgment on the note, a person can file the motion to void the judgment lien just like any other judgment, just like a credit card judgment or anything like that. So we can eliminate a portion or sometimes all of that judgment, and we can file the quiet title to completely absolve people of this second mortgage. So keep that on your radar. I think home values, this is my opinion, of course, but I think home values are going to keep going down for the next couple of years. I don't think we'll see as sharp a drop as we saw in 2009, 2010, but I still think there's going to be a drop off, and people with limited equity may have these other issues on their title, like old second mortgages or judgments that we can help take care of, or again, any attorney in Oregon can help take care of. All right, tax liens. A lot of you may have had this problem where people have a tax lien. Sometimes it's even hard to get the IRS to give a payoff. I know title companies get frustrated. I get emails saying we've asked and asked and asked, and they won't give a payoff, and there's nothing else I can do either other than ask and ask and ask. But that's what we do, and we try to hit them from both sides. But a lot of times people can file a motion. It's not a motion. People can file a form with the IRS asking the IRS to remove its judgment lien. I don't know if there's a process. I know the beginning point of the process is to file the particular IRS form. You can email me later and I can look up the forms. These are things that come up once every 2 or 3 years, and I can't memorize the form numbers, but the IRS has a couple of different forms they use in different circumstances when there's a tax lien on property and people want it removed so they can close the property. Typically, the IRS is only going to reduce their lien sufficient so that the property can close, not so that any money can get paid to the home sellers. But I have seen circumstances where the IRS gives money to the home sellers. The most recent one was a divorce case, and the tax lien was against husband. And the marriage always had financial difficulty, and the parties always filed taxes separately. So the wife didn't owe any taxes. And we attached to the form a breakdown of with the estimated closing statement. We gave everything we could to the IRS, and the IRS did release the lien on 1/2 of the proceeds. And it was a pretty good chunk of money. The total equity in the home was like $250,000. So the wife was able to walk out with about $125,000, and the IRS reduced its lien and only took a lien on husband's 1/2 share of the home. So the IRS did look at that and say, hey, this is a fair deal. We really shouldn't be taking wife's half of the property. So don't assume that the IRS is not going to release the lien, but definitely with the IRS, it's kind of like the bankruptcy court. You got to get the forms filed as quickly as you possibly can, because you don't know how long it's going to take to get the right person at the IRS. In addition to emailing me and asking, you can get on irs.gov and just do a search in their little search bar for void tax lien form or something like that. And probably what you need will pop up. Also on that form, it explains where with the IRS you should submit that form to ask them to release the lien. Okay, last issue I wanted to cover before questions is divorce issues. This problem, I don't know, it seems like it comes up a lot for me. Financial issues can have a negative effect on marriage, and so a lot of people in bankruptcy are also in divorce or had a prior divorce or something. So the two go hand in hand. So there's a lot of divorce issues related to title and home sales. The few things you have to look at separate from any bankruptcy issues in divorce is what the divorce says about who gets a property. The typical way for a divorce to be written is for one spouse to get the property and the other spouse to have a lien on that property to account for the equity that that second spouse gave up by signing the property over to the first spouse. Typically, divorces will have some time frame that the home needs to be sold, or the what's called equalizing judgment gets paid. And then if it doesn't, then the spouse who didn't get the home can go back into divorce court and say, hey, judge, force my ex to list the home for sale. When that happens, the divorce judgment lien is unique and different than other judgment liens. Since a divorce judgment lien happens simultaneous to transferring the property to the other spouse, an attorney cannot eliminate that lien if it if it encroaches on the homestead exemption. So that was not a very good sentence, but I'll try to give an example that makes it more clear. So husband and wife own a home worth $200,000. There's a $100,000 mortgage on the home. And so the home gets put in husband's name. Wife has the equalizing judgment of $50,000 on the home. And then later on, husband says, well, I'm going to sell the home. Problem is, later on, the home value went down because we're in a recession, and the home's now only worth $140,000. There's 100,000 still owing on the home. There's 40,000 equity, but ex-wife has a $50,000 judgment plus interest usually. And so husband can't sell the home without wife signing off. Now wife is going to say, and the husband's going to say, well, I still want half the equity in the home. I want 20,000. And wife's going to say, no, I have a judgment for 50,000. The law does not allow us to void her lien as appearing his homestead exemption because the lien was obtained as part of the whole transaction where he got the whole of the home. The opposite can happen. Home values can go up and the one spouse can say, man, I really got ripped off because now I only have a $50,000 judgment. There's nothing that spouse can do about that either. Property judgments in Oregon are fixed. Support issues like child and spousal support can be amended over time, but the property division part of a divorce cannot. The only way to ever overturn a property division is to prove that the ex-spouse defrauded the court, hid assets or whatever, which is almost impossible to ever prove. So a lot of times when you see a post-divorce issue and one entity has a judgment lien, that full judgment needs to get paid out of sale without that person voluntarily signing off and agreeing to accept less. All right, divorce. Let me just look through my notes and see if I missed anything I wanted to cover. All right, I think that's basically it. Hopefully somebody has some questions and I can clarify anything I might have missed.
Ari, did you want to add anything before we went into questions?
I put it in the webinar chat, but I just wanted to feed off of what Rex has said about holdbacks on bankruptcy judgments, and Western Title does not do them. I cannot speak for the other title companies, but sounds like based on Rex's experience as well, that's probably been eliminated across the board with most title companies. So we would not even be honoring that or going down that road.
Perfect. Okay, so a few questions here. One, has anyone sued for the unfairness of the allowed amount? And I believe that's in reference to the homestead exemption.
I have, if the question is, has somebody sued saying the Oregon homestead exemption isn't constitutionally valid or something, someone shouldn't be allowed their full homestead? Those suits have happened, but they always fail. The arguments people have made is that, well, our judgment is based on fraud. And so since so-and-so homeowner is a bad actor, he shouldn't be allowed his homestead exemption. So that argument's been made. That issue actually went to the Supreme Court of the United States, not from Oregon, but from a California court. And the Supreme Court said, doesn't matter how scummy someone is, people get their homestead exemption. It's way up here on the list of rights. It's a property right. It's protected by the Constitution, and you get your homestead. But if the question is, have people argued about the home value? Yes, we see that. It's not super common, but a lot of times, you know, people, again, they're going to click on Redfin or Zillow, and if they see a high value, it's hard to convince them that they're wrong. It's hard to convince, and it's usually in cases where whoever has the judgment entered the judgment on the property. It's not a major entity, right? It's not U.S. Bank. U.S. Bank is going to be very practical and say, is this a debt issue? Are we going to get money? And that's going to be it. But it's usually like an ex-business partner who sued his business partner, and his business partner over the years told him how beautiful his house is and how he has granite everywhere, and you know, it's top of the line, and his home's worth more than the next door neighbor. And so somebody's been bragging about how great their home is, and then of course the ex-business partner says, well, no, this home isn't a run-of-the-mill home. It's definitely worth more than this guy's saying, and I want a hearing and prove to the judge that this home is is worth way more than he's selling it for, and I'm the one getting ripped off because my judgment's not getting paid. That did remind me of one other thing I wanted to talk about. You might wonder why somebody with a judgment wouldn't just pay it, because it's still a judgment. If somebody sells their home, we avoid part of the judgment lien, so only a portion gets paid. You have somebody who still has this judgment they have to pay. So there's a couple reasons that they may want to void the judgment lien and get as much money in their pocket. One is they may be leaving the state, and it may be difficult for the judgment creditor to collect on that judgment. And so they're fleeing town, and they're, by the time somebody catches up to them to find the money's spent. Or they may be planning on filing a bankruptcy. A homestead exemption is valid for a year. So if I sell my home today, as long as I segregate that money, the homestead exemption money, then I can later file bankruptcy. And even though that money is at that point cash in the bank, the court can't take it because it was derived from the homestead exemption. And the third reason is they may want that cash in order to settle the judgment. Because if I have a judgment against somebody and they have $50,000 in the bank, they say, hey, Rex, I'll pay you 25 to settle your judgment. I might want to take that amount, because that's a lot easier than trying to go after them or collecting it or watching that money all get dissipated in the next year. So there's a lot of good reasons where somebody might want to avoid the judgment and then use that money after the transaction closes to try to make a deal on that debt or other debts.
Do you happen to know off the top of your head how much the homestead exemption is for Deschutes, Crook, and Jefferson?
Yeah, they're all the same. It's $50,000 for a married couple, $40,000 for non-married individual.
Perfect. Next question is, how backed up are foreclosures in Deschutes County?
That's a great question. I think they're very backed up. With all the moratoriums, everybody who got behind during that time, they're still sitting out there. And mortgage companies, from my experience in the last 6 months, they're not nearly as willing to do a loan modification as they used to be. Prior to 2010, there was no such thing as a loan modification on a mortgage. And then the government started giving mortgage companies $1,000 to modify a mortgage. And one of the programs from 2010 or 11 also gave the homeowner $1,000. And so everybody had incentive to modify mortgages, and mortgage companies built up these huge loan modification departments and processed millions of them. And then they kept those departments open even after all the incentives and everything from that recession ended. So mortgage companies kept doing modifications, but made it harder and harder and harder. I've seen just a lot of letters from mortgage companies in the last 6 months saying, you don't meet our qualifications. And they don't even say what the qualifications are. They just leave people out there saying, well, I guess I didn't qualify. And then people either have to sell their home quickly, they have to file a Chapter 13 and repay the mortgage payments through the Chapter 13, or they have to let the home foreclose. So I think there is a significant backlog. I think mortgage companies aren't going to be very willing to modify. And there's not very many attorneys who do foreclosure. And so I don't think, I think the backlog, it's all going to hit us at some point, but I think it's going to be spread out over a long period of time. I think we'll see more and more foreclosures, but I don't think we're going to see a huge wave just because the mortgage companies can't get to them and the mortgage companies' attorneys can't get to them fast enough to create the wave.
How does a judgment work if the two homeowners are not married, since you wouldn't have a divorce decree to refer to?
That's a great question. So I kind of, the 50,000, the way the law is written, can be a married couple, or it can be two people who both owe the debt. So if you have joint homeowners and they're both joint on a judgment debt, then the homestead exemption for them combined is 50,000. So they can't take 40,000 each because they're not married and claim 40,000 on their 1/2 interest in the home. If the judgment isn't against both of them, if the judgment is only against one, so they're joint homeowners, but they're not joint obligors on the judgment, then each homeowner, with some exceptions, is entitled to half of the home. And we can claim the 40,000 homestead exemption for the one who has a judgment. So you can have a home with 80,000 of equity, and if the judgment is only against one of the two homeowners, then we can void that whole judgment lien because we can utilize the 40,000. And that actually happens a lot. There's a lot of circumstance where there's multiple owners on a home. They've usually related, but sometimes they're not even related, but there's a judgment only against one of them. The argument the creditor can make is that whoever the judgment is against actually owns more than 50% of the home. And you can't tell just by looking at the document, because the document can say these two people own this jointly, 50-50, however you want to write it up. But if one owner has put in all the money and the other owner has put in nothing, then a judge can still say, in reality, party A owns 100% of this home. So that's somewhere where you get into that big legal argument, and usually the timing of that argument makes it not work for anybody. But yes, just because on paper it looks like two people own a home 50-50, that doesn't mean that's how a judge is going to make a determination.
This one is a little bit more specific, so let us know if we can't wade into these waters.
Yeah.
How does a bankruptcy affect a home being sold with a contract of sale and a filed memorandum with payments collected by a third party, which pays the first mortgage and the difference goes to the seller?
So if I understand correctly, they want to do a contract over time. Is that how you read the question?
Yes.
Okay, so I've actually had that a few times. It's a little more difficult to get the judge to agree to it. But if all the parties agree and the transaction's fair, the judge can agree and say, okay, yes, seller can be a person in bankruptcy and seller can accept contract payments over time. It's definitely going to be a requirement that the seller pay the underlying loan with those payments first. I don't think there would be any circumstance where the judge says, well, the seller has this $200 a month positive cash flow, I'm going to let him keep it. I don't think any judge would allow that. I think the judge would say, even though the underlying mortgage payments are $1,000 and you're collecting $1,200 a month, you got to pay that whole $1,200 on the underlying mortgage, so it's extinguishing that lien as quickly as possible. But those kinds of transactions can work in bankruptcy, but it's going to be a higher scrutiny that the judges can determine whether it's a fair deal.
Another question regarding married couples. So married couple, but only the husband owns the home and has the loan. The wife has creditors and wants to do bankruptcy on her creditors. Can they come after the home?
That's a perfect question. So my two answers ago kind of alluded to the same thing, but a judge, either in bankruptcy court or in Deschutes County, the judge can determine the percentage ownership of a home, regardless of what it says on paper. So the questions that will be asked is, wife, how much did you work during the course of the marriage or since the home was purchased? How much of the down payment came from husband or wife? And there's not a specific formula or anything. It's just the judge's determination saying, husband has put in 100% of this money. It's a short-term marriage. The down payment came from pre-marriage sources of money or husband's IRA that he'd built up before marriage or whatever. And a judge is going to say, I think husband owns 87% of this home. And so if wife's 13% ownership is less than her 40,000 homestead exemption, then the bankruptcy court will not require them to sell the home. They'll be able to keep the home. But when only one person is on title and it's a married couple, even if it's a non-married couple that have been together a long time, the court is always going to look at what really is happening with the money to determine who owns what portion.
Perfect.
The big problem, the similar problem, is a lot of times older people want to avoid probate. And so instead of setting up a trust and putting a home in trust, they just sign the home over to their kid. And they don't assume their kid has a bunch of debt, right? So now all of a sudden you have this process where you have a home, sometimes free and clear, no mortgage, a lot of equity in somebody's name who has a whole bunch of debt. And it's easy to make the argument that grandma did this for estate planning purposes and it's really not his home, you know, until she dies. But it's also easy to make the other argument and say, nope, she intended this as a gift to him, no strings attached, it's his home, and his creditor should be able to grab it. So it is an issue that comes up frequently, and hope that answered the question well enough.
In your example of the IRS releasing the tax lien on the wife's portion, how long did it take to hear back from the IRS?
It took about 2 months from the day the form was sent to the IRS. It was about 2 months before the IRS did the release.
Those wheels don't generally turn quickly.
Not quickly.
Just to add on to that from what Rex was saying is what you frequently come with the IRS is that they state that you didn't complete it correctly the first time around, then you have to resend it, then it gets to the wrong person, then it's a constant dance. So even if you think you've done it correctly the first time around, just assume it's going to take 60 days to actually get what you need from them.
Yep, and call them every 3 days with your nicest voice. And oh no, I say you, not you. You have the homeowner, the home seller do it. And you just say, be as nice as possible and tell the IRS guy your sob story and make the IRS person your best friend.
Well, that's all the questions that we have. I think it's safe to say that every case is going to be a little bit different. And so from a title insurance standpoint, please remember that we are a resource for you far prior to ever being in a transaction. If you have questions, about a unique situation, we can certainly do our best to assist, again, far prior to being in the transaction. So Rex, thank you for your time. We will send out the—
My pleasure. And shoot me an email if you have questions. And if you say, well, what's your email address? This type Rex Bankruptcy Oregon. And I'm the only bankruptcy attorney in Oregon named Rex. And then you get on my website and they click on my face and you can email me. And that way you don't have to write down rdaines@olsondaines.com, which is hard to remember. So feel free at any time, ask me a question. I'm happy to answer it.
Thank you. We'll include your contact information in our follow-up email as well. If you're here for CE credit, we will be getting those certificates out by the end of the week. So keep an eye out in your email for those. Thank you so much for attending. And thank you again, Rex.
My pleasure.
Thank you.